Ladies and gentlemen, thank you for taking the time to be with us today for the M&A Academy program and our eighth session of this webinar in the 2025 series. My name is Neha Janakiraman. I'm a partner in the dispute resolution team at Sirar of New Delhi. I specialize in commercial litigation and arbitration. I would like to extend a very warm welcome to all of you who've taken the time to join us today. The M&A Academy is a program designed to provide foundational legal knowledge and understanding in the M&A transactions phase. Today's topic, however, is interestingly on the enforcement space. It is on what to expect in arbitrating M&A disputes. On the next slide is the agenda for today's webinar. The format of the discussion today will be a panel discussion followed by a Q&A session. Thank you to everyone who's taken the time out to send us your questions in advance. We will, of course, make every effort to answer it through the course of the webinar, but should we not be able to do that, we will send our responses offline. Also, a summary of the webinar as well as notes will be shared with you for your reference. M&A is a very important sector of practice for our firm, with over 50 partners dedicating their resources to this area. India has seen an unprecedented increase in the number of transactions in this sector. Arbitration, of course, is the preferred mode of dispute resolution, given its confidentiality, flexibility, and enforceability on a cross-jurisdictional basis. However, our aim today will be not only to explore the arbitration landscape, but also alternatives to the same, given the effective enforcement resolution mechanism required in such transactions. In today's discussions, our experienced panel will give us their views, not only on a theoretical basis, but also a practical end-to-end experience in running such arbitrations and their pitfalls and what to do and what to be avoided. Our panel today needs no introduction. You will have received their CVs along with your registration. Both Karthikeya and Raj are leading practitioners in the commercial litigation and dispute resolution phase and international arbitration space. Raj sits out of our new Mumbai office, while Karthikeya sits out of our Singapore office. So without further ado, let's get to the discussion. First up, Raj and Karthikeya, and this one's open to the both of you. What are the most frequent types of M&A disputes that end up in arbitration in India, and how do they typically arise in your experience? Raj, would you like to take this up first?
Sure. Thank you, Sneha. The complex nature of M&A dispute itself has made arbitration increasingly popular. Right? That's the most preferred way of resolving disputes. We generally see quite a few kinds of M&A disputes that arise in the day-to-day transactions. We've seen breach of representations and warranties as the main arbitration that we see all the time. We see post-closing purchase price adjustments issues. We see announced disagreements. We see indemnity claims that are arising out of the arbitration. In arbitration, we see clauses which are triggered by material adverse change, the breach of regulatory representations, and of course the famous put and call options. We also see funding obligations quite a bit being triggered. And in the recent context, we see a lot of tariff-related issues that may come in. So we generally see these kind of issues coming out on a regular basis. Like very briefly, if you want me to, I would say that a breach of representation and warrant is generally when you have committed to a certain aspects in your agreements, and if those are not met, you will generally see disputes getting triggered. Similarly, for post-closing purchase price adjustments, the disputes are arising on final purchase price adjustments, which are paid after the transaction closes. And we generally see that there is always some disputes arising out of the manner in which these adjustments are taking place. So we generally see these disputes coming very regularly. Karthikeya, you may have some other issues that you may want to point out.
Well, thanks, Raj. You're absolutely spot on that these are actually some of the most frequent kind of M&A disputes that we see. But just by way of example, I want to touch upon 2 or 3 other kinds of disputes. For all the viewers, I think they must be aware that India is a highly regulated market in which a lot of sectors require approvals from their sectoral regulator, whether be it the competition regulator, whether be it insurance regulator, whether be it RBI, when the foreign investment is coming in or the money is going out, and other regulators for other specific sectors. And in India, this is a very peculiar problem that you end up getting a lot of approvals for a cross-border or a domestic M&A to actually materialize and close. So I have seen a lot of disputes in relation to these regulatory approvals. Who bears the risk? Let's say there was a US purchaser and there is an Indian seller. The agreement says that the seller needs to take best efforts to secure all approvals, and the competition approval did not come through. How will you determine what kind of efforts was the seller supposed to take, which would qualify as best efforts? Is it a defined term? And let's say it did end up going and doing what it had to, which any other ordinary seller in those circumstances would have. But still, can they be missing gaps in those risk allocation? So these are the regulatory related disputes that I have seen in an M&A context, and then eventually a tribunal or a court needs to determine on whose liability it is under the contract. The second kind of dispute, again, which was very popular because of a live case, is relation to termination of break fee payments. Now, the M&A transaction contemplates that the parties will work towards closing a transaction. What happens when the transaction is not closed because of the fault of one of the parties? Will the deposit be forfeited or will a break fee be given? And as viewers may recall, that it was this famous Z Sony merger in which this break fee was at the central pivot of the dispute. And as you would recall, under the Z Sony scheme, a proposed scheme arrangement, basically there were a lot of governance related steps that had to be taken. Someone had to get in control of the company from the Z side, and then there was dispute whether that person was the right person to take control of the company. And eventually Sony decided not to go ahead with the merger, and then it ended up suing Z for break fee, as a result of which that dispute ended up going before SIAC arbitration, and we never got an award because the matter settled. But that was a clear example of how, when parties fail to close a transaction, can lead to a potential dispute, whether be it arbitration, court, or any other mechanism. And Raj, you alluded to price adjustment. I think that itself is a very, very relevant example because you end up seeing in so many M&As that parties end up presuming that there'll be certain conditions which would be met, on the basis of which there'll be deferred consideration. And if there is a change in those conditions, then there can be a readjustment of the price. Parties end up trying to negotiate very complex formulas, accounting principles, etc., for such a price adjustment mechanism. And there can be just certain change in circumstances which can basically derail the expectations, can potentially move upwards or not or downwards the price of the deal. And then parties hopefully would have accounted for that risk in their accounting formula. But it's also the case many times that people don't see it through, which also leads to that dispute between the parties. And that's again very, very common. And one last thing that I do want to allude is that in an M&A context, while we are speaking about a lot of these disputes which are pre-closing, but actually post-closing, there are enough number of disputes which happen. The India Bulls and Bessie proposed share swap merger was one such dispute in which they wanted to create a pan-India real estate platform. They got all the approvals, but then NCLT rejected the scheme on the basis of certain overvaluation. They thought that actually the deal is quite overvalued and we cannot stamp this merger scheme. But luckily, it was overturned by NCLAT and the Supreme Court. And they said that a tribunal cannot go behind the wisdom of the shareholders, and they cannot go and say that it is actually overpriced. What I'm trying to allude to is that when you are agreeing to all these commercial considerations, there are also minority protection rights. And if those rights are somehow tattered, then they will have recourse before courts in India for oppression and mismanagement and for protection of their rights. But for overvaluation, that may not arise. But those things need to be kept in mind so that the minority is not squeezed out when it comes to a merger context. Similarly, the other post-closing things that we have seen is employment-related restraints being breached, or there are certain IP-related transfers which are not effected properly. So all these are post-closing M&A disputes, which are also fairly common in an Indian context. Over to you, Sneha.
Thank you, Karthike. Yes, actually, risk allocation is a bit tricky, isn't it? Like, even for anticipated risks, the regulatory structure could just put a spanner in the works, which actually leads us to sort of a nice segue into the next question for you, Karthike, which is, are there any patterns in deal structuring, due diligence, or negotiation that tend to create arbitration-prone disputes in your experience?
Sneha, the short answer to that is absolutely. There are enough number of things that I have seen in M&A disputes which can lead to certain decipherable patterns. When you look across the entire spectrum of M&A disputes, you will see certain things being very common. The first is that there are overly compressed due diligence timelines when it comes to an M&A transaction. And repeatedly, I have seen my transaction partners struggling with those timelines because the clients are overtly demanding. They are also not willing to pay good premium rates for conducting this due diligence. And actually, this is the most important phase of an M&A. You have to really assess whether all the information which has been represented by the seller, by the buyer, is true, and you have captured all that information accurately to factor in the risks when it comes to drafting stage. But more often than not, the timelines are so compressed. The bankers end up deciding, let's try and close the deal in the next month for a company which has had operations in so many cities in India, or let's say a global multinational which has operations in so many countries and is trying to acquire an Indian entity. You can just be overwhelmed with the amount of documentation which is there, and it is impossible to try and close such deals in a month or two's timeline. So a poor diligence exercise because of compressed timelines can actually lead to a lot of issues later on. The second is when it comes to the drafting stage, they can be imprecise or vaguely drafted provisions. One example can be earnout provisions, which I have seen in M&A disputes, in which the parties don't clearly define what kind of accounting practices or what kind of adjustments need to happen when a certain event takes place. And any ambiguity in any of those things can lead to a lot of confusion in the overall formula in which the earnout had to be done. As a result, the parties will end up going before a tribunal to try and get it resolved. The third thing is that when it comes to M&A transactions, just because, and it's again tied to the first point that I made, which is compressed timelines, and parties not willing to pay the premium for when it comes to conducting the transaction documents and drafting them, is lawyers end up using often boilerplate clauses. And that's because you have very little time. The clients are not willing to pay premium rates, as a result of which you want to use some sort of a precedent to try and get the deal done quickly within the timeline agreed. And that leads to a situation in which parties are not able to think through all the risks which can arise in that particular transaction and then factor them in by clearly defining where the risk allocation would be there, or how to ensure that, frankly, the parties have captured all possible scenarios which are there, which can arise from that point of time until closing and thereafter to ensure there is no dispute. So I think all these things are very common, which lead to a lot of disputes in India. And I can tell you that if there is a word that has always stuck with me, it is ambiguity. It is the single biggest driver of M&A disputes in relation to Indian parties. Slowing down just enough at the structuring and at the drafting stage can actually do wonders for the parties when it comes to eliminating the risk or significantly reducing the risk of that M&A deal getting into a dispute eventually.
Thank you, Karthike. So you did, I couldn't agree more on the compressed timelines and the necessity for stronger diligence before you get into a transaction. You did mention, the wider the locational or structural reach of the company, potentially the more complex is one of the factors that you consider. My question to you, Raj, on this front is, do you see such disputes as being sectoral or more prevalent in certain sectors, or do you think it's sector agnostic in that sense?
I'll tell you, there are certain sectors in India which has higher incidence of M&A arbitrations clearly. Some of them which are regulatory driven by regulatory requirements, so regulatory complexities, deal sizes. Some of the sectors have high risk profiles, right? So some of these issues you will definitely see that there are much higher risk of going into arbitration. We've seen in the past sectors like pharmaceutical and healthcare have very high value transactions and complex regulatory frameworks, which take them to undoubtedly take them to a post M&A or M&A disputes. We've seen in the past the famous case of Daiichi Sankyo and what happened to in that matter because of the representations and warranties were not clear. We've also seen sectors like financial services and banking, again very heavily regulated sectors in India. You'll definitely keep seeing disputes arising on a regular basis. You will always see that there are too many undisclosed liabilities, performance targets, regulatory sanctions.
So actually, Raj was alluding to the fact that regulated sectors see more disputes in this area, which brings us actually the next issue that we want to address, Karthikeya, which is for you. The assumption that arbitration is a good fit for dispute resolution across board is potentially maybe flawed. In your view, what kinds of M&A disputes cannot or should not be referred to arbitration, and why?
So, Sneha, you're spot on that the assumption that arbitration is a panacea for every kind of M&A dispute is actually wrong. I think people really have to understand what kind of a transaction they are entering into and what kind of disputes it can lead to eventually to try and figure out which is the most appropriate dispute resolution mechanism, whether be it arbitration or something else. And the dividing line when it comes to referring a dispute to arbitration or not under Indian law is actually on whether certain rights are rights for the public and those cannot be arbitrated. And there are other rights which are personal rights, which are known as rights in personam, as per the jurisprudence in India, which should be arbitrated. That is the first starting point. When it comes to rights of the public or engaging with regulators or sectoral bodies who may become parties to such a dispute, or if there are multiple parties, then possibly arbitration is not the best suited mechanism. And I'll deal with each of these below. But the short point that I do want to say is that arbitration is a scalpel, it's not a sledgehammer. It's not something which is precise for all disputes. It's precise for contractual disputes, but is inadequate when it comes to public law related disputes or regulatory disputes. And let me deal with each one of these by giving you one example. Let's say there is a statutory prohibition first that certain disputes cannot be arbitrated. What are these kind of disputes? When it comes to insolvency, winding up, operation and mismanagement, public trust related disputes, criminal law matters, they cannot be arbitrated. They are actually decided by courts so that you can have a final judgment because it impacts the public at large, as a result of which arbitration is not suited for such disputes. The second is in relation to cases in which you require absolutely urgent interim relief. While arbitration has emergency arbitration as one mechanism, the second is when the tribunal gets constituted, you can ask them for interim relief. But what people in the arbitration landscape face difficulty with is when it comes to enforcement of such interim relief. When it comes to emergency arbitration, the enforcement is not as easy. But when it comes to getting an interim relief immediately from the court and then trying to enforce it because the other party is not obeying, it's actually much more effective because the court can actually issue a contempt notice immediately. Then the other party would be a bit scared. They'll try and ensure that the court is not upset with them anymore, which can lead to effective enforcement. The third is when it comes to third party rights. So arbitration as a dispute resolution mechanism is by its very nature consensual. The parties have to agree to an arbitration clause to govern the relationship between them. And in case a dispute arises, then that arbitration clause will refer the matter to arbitration. But if you have third party rights which are accruing, those parties not being parties to the contract, let's say there is a transfer of someone receiving the asset to another party under the M&A transaction, and that other party was obviously not part of the closing related transaction documents, then if you want that asset to be returned back to you, you cannot really go for an arbitration because the tribunal will have no jurisdiction over that third party. So the potential recourse is to go to a court and then ask for unwinding of the transaction. That is one example. The second is that As a party, you may have issues with the regulators. You may want to go and challenge the decisions that the regulators did when it comes to, say, refusing an approval or giving an approval with certain conditions which you think are unfair. Then obviously a regulator cannot be made a party to an arbitration proceeding. As a result of which, you have to go to a court and then challenge the actions of such regulators. And the last example that I want to give is in relation to multi-party disputes. Increasingly, transactions are becoming more and more complicated. Whenever there is a rights transfer, it's not only a transfer from a holdco to another holdco, there can be subsidiary or sister companies which are involved. And when they are not parties to the particular transaction document, it is very difficult to bring them as a party to the arbitration proceeding. Or if there is an arbitration proceeding, it can impact the rights of that third party, which is a related party. And in those situations, you may want to go to court rather than arbitration, because trying to involve them or join them as an additional party in an existing arbitration proceeding can be very complex. It can make the proceedings really long. It can make the proceedings really costly. Whereas in a court, they are very well equipped when it comes to handling multi-party disputes at the same time, and those timelines don't actually change. As a result of which, for these kind of disputes, potentially court proceedings are much better off than arbitration. So in short, Sneha, it's basically statutory related prohibitions in which arbitration is not applicable, things which require absolutely urgent relief, which require effective enforcement. Third, joining third parties like regulators or other third party rights were created. Fourth, which is in relation to multi-party disputes in which things become very complex, that arbitration is not the most suited mechanism for it.
Thank you, Karthikeya. Actually, can't agree more, especially when we're talking about effective interim relief, which is often one of the most sought after goals when you're entering into an arbitration in most instances. Um, which takes me to really the next question that we have, which is that at what point in a transaction should parties make this assessment of whether arbitration is the appropriate dispute resolution mechanism for that transaction structure or not?
So I think I may have already alluded to it in the beginning when you started asking me the first question, but effectively, the parties need to start thinking about the dispute resolution mechanism as soon as possible. And what happens in practice is that parties end up deciding on the dispute resolution mechanism towards the end, and usually it is a boilerplate clause. But because there is such a dynamic deal making as the lawyers are going through the deal, negotiating with the counterparty, trying to put all of that in terms of drafting in the transaction documents, there is a lot of dynamic environment involved, and they know where the risks are. They know what can go potentially wrong. As a result of which, they need to start thinking about dispute resolution mechanism at that time, discuss with the relevant party and tell them that these are the pros and cons. If this thing goes south in a particular way, this is why arbitration can be useful, or this is why a certain other mechanism can be useful. But all of that has to happen in the beginning. And what happens is the complete opposite. And you, I, Raj, everyone else in the dispute resolution practice is a recipient of midnight calls from our colleagues asking us that we are going to go for SIAC or LCI. Is that the right thing? And obviously, if you wake up someone from sleep and ask him this thing, you're not going to get the best answer, right? So you just need to think for all of this, factor all of this since the beginning, give it adequate consideration and time, and discuss with your dispute resolution partners as to what is the best mechanism to factor this risk when it goes into a dispute.
Thank you, Karthikeya. So we've been, focusing a lot of attention, of course, on, arbitration and its effectiveness and its suitability for various scenarios. Raj, this one's for you. In your view, what are the main alternatives to arbitrations for M&A disputes in India, and in what sort of scenarios, in your experience, should these be considered before?
Very important question, and thank you for this. I think every organization that goes into is doing a transaction, the primary goal of the organization is to carry on business. They do not want to fight, right? They want to ensure that the dispute comes last in their entire mechanism of resolving disputes. So we see multiple levels and multiple ways in which the matters can be resolved. I've seen on the commercial side, the most important and the most used one is the negotiations between the party, because that helps senior level people to come in and before the positions have hardened to try and see if the matters can be resolved commercially. And that's probably one of the best way to resolve the matters. We've also seen people using different mechanisms and methods like expert determination to arrive at a valuation of issues, to see what are, is there any purchase price adjustments that would be required to bring commercial value to the transaction. They are of course technical in nature, but they are used far more often before you actually resolve or go down the arbitration or mediation path. And that's one of the second method which we see regularly being used by parties. If that fails, we always got a little more formal methods of mediation and conciliation, which parties use on a regular basis. Of course, mediation is more of a non-binding process. It's where a third party comes in and facilitates the negotiations between the parties, and the settlement that is arrived at during this mediation process is now enforceable as if it is a decree of the court. Uh, India has already adopted the Mediation Act for the domestic disputes. Of course, for cross-border disputes, India is yet to ratify the Singapore Convention on Mediation. But for the domestic disputes, we're seeing a lot of that being now resolved through mediation. That's also because the Commercial Court Act now prerequisites requires you to go to mediation before you actually go into a dispute. And even if you go to disputes without going through the mediation process, the Supreme Court has very clearly now stated that you are required to definitely go back to mediation before you proceed further with the disputes. We've seen this provision being used very often. A lot of high value commercial disputes are now getting resolved through mediation, or at least earnest attempts are made to resolve these disputes through mediation. And of course, you also have other methods like for an M&A dispute, you'll also always have methods like going to National Company Law Tribunal, invoking the provisions of the MOA and the AOA, and go down that path as well. But I think these are the various other options that parties use to resolve the M&A disputes.
Thank you, Raj. Um, well, negotiations, mediations, conciliations, as you rightly pointed out, could be a far more effective tool for resolution where parties are actually willing to take that step. I suppose arbitration still remains the front runner in situations where parties are still adversarial or not and not willing to sit across the table to have that discussion, or that stage is well past. So in arbitrations and M&A disputes, Raj, what is the typical duration that you see it takes from instituting the proceedings to rendering of the award?
So arbitration, as you know, has two, three aspects to it. If it's a domestic arbitration, and M&A disputes, which is a domestic arbitration, you of course have now the act itself giving you timelines to complete your arbitrations within a time-bound manner, which starts with 12 months to complete your pleadings, and then you have up to 12 months to 6 months to complete your pleadings and 12 months to complete your arbitration, with extension, with parties agreeing to consent for another 6 months, and thereafter going to court for seeking further extension. In a cross-border international commercial arbitration, the timelines are not prescribed under the Act. We generally see that complex arbitrations do take around 18 to 24 months to complete. That's generally the timeline within which we see the arbitrations getting over. Of course, this also depends on whether it's an ad hoc arbitration, if it's an institutional arbitration, availability of the arbitrators, availability of the parties, how parties are conducting the arbitrations. You'll see many a times there are the parties who just want to delay the process, and will use every trick in the book to delay the process. So these things do happen, but arbitration is not the only thing that you have to keep in mind when it comes to timelines. You also need to factor in the number of court interventions, going back to court on various occasions, or at the end, ensuring that whether the award is challenged, and if so, how long will that take, and plus the enforcement mechanism of the award. So I think all in all, you need to keep all of this in mind. But arbitration, by and large, would take around 18 to 24 months to complete.
Thank you, Raj. Actually, that's a very good point you make, right? So the timeline for an arbitration is not restricted just to the arbitral process, but court intervention, which is a major factor. Which actually is a good segue into the next question, which is that recently, or we've seen a lot of influx of investments into entities trading off to others. PE investors typically invest and exit on a time bound horizon. So Karthikeya, this one's for you. How can the existence or prospect of an arbitration in an underlying M&A transaction involving such an entity impact the deal making?
Thanks, Neha. I mean, if there is an arbitration which is ongoing, I can tell you that it is not only confined to the parties and the tribunal. It actually infects the boardroom, it impacts the shareholders, and as well as the balance sheet of the company as well. What do I mean by this statement? Let me just take you through certain examples. The first is that there can be delays in post-closing obligations because of an existence in arbitration. When it comes to earnout payments, deferred consideration, or indemnity payouts, they all can be withheld until a decision on how much amount under each of these categories is to be finally determined by the tribunal that award comes out. Unless and until that award comes out, which finally determines this, the one of the parties may say that we will not go ahead and close the deal. So that is clearly a delay in one of the obligations or post-closing obligations when it comes to an M&A transaction. The second is triggering of contractual protection slash MAC clauses. The initiation of arbitration can at least be cited or argued as a material adverse change event under the contracts, depending on, of course, how the contract is drafted, what kind of language is used there. But that in turn can derail the ongoing obligations or provide an excuse for the counterparties to renegotiate the terms of the contracts. The third is financing complications. And this is when I said that it can impact the balance sheet. That the moment you have an existing arbitration in which something is claimed against you in that as a potential damage, you will have to reflect in your balance sheet, in your accounts, that listen, this can be a potential liability if we lose this arbitration. And as a result of it, there can be banks and financial institutions who may not be willing to actually extend any form of financing to you, or can tighten the screws on the loan terms that they were giving before. As a result of which, it can make things slightly more difficult for the company when it comes to taking on fresh loans to run its operations. The fourth is deterring follow-on investments. Now, if again there is an overhang of an arbitration, which not only is minor, but actually can cause a significant derailment of the company's operations because it can be a significant liability against the company, uh, you can potentially see a company not attracting more and more investors. So let's say a company has had its first or second round of funding. Now it's facing a big arbitration claim, and now it's looking for a complete takeover by a foreign entity. The foreign entity gets to know that there is a big arbitration award which is potentially against the company, which is currently ongoing, which can result into an award eventually. And the foreign entity may say that, listen, I don't want to do anything with you unless and until this arbitration is over and you're scot free. So again, it can deter follow-on investments. And the last thing that I have seen very often in, with all my clients is that when there is an arbitration, you're obviously taking away all that management time that you would eventually use for running the company, but to try and resolve the case, something which has happened in the past, you're trying to right what the wrong has happened, and you take away all the management time. You incur significant amount of cash when it comes to engaging lawyers to try and defend you in arbitration. And it's just like a big distraction for the management, which no one really likes. And that is why some of the senior level CEOs, CFOs, they get a bit impatient with the length of the arbitration proceedings. So these are, Sneha, in short, five important things that I have noticed, which can be relevant from a deal making point of view.
Thank you, Vatike, pitfalls to watch out for. But what, in your experience, are the most common mistakes that parties make when arbitrating M&A disputes?
Sneha, much like there being a common thread when it comes to the kind of disputes, which I already alluded to, there is also a common thread when it comes to pitfalls, when it comes to arbitrating M&A disputes. And I made 5 points in my previous question. I'll make 5 points here by way of example. The first is when it comes to poor document preservation. I think more or less disputes are won or lost on the basis of the contemporaneous documents that the parties have and the kind of position they have taken in those documents. And many people don't actually end up thinking it through when it comes to shooting emails to their counterparties, especially on the business side. They don't think it's worth getting it vetted by lawyers, whether be it internal and or external lawyers, and they just say something which can come back and bite them really hard. And second, in relation to this, is that just when it comes to all these emails, etc., they may not have document retention policies in a company. All these documents may not be preserved. So while you have, shooted out certain emails to other parties, they may have the benefit of all those emails, but you may not have them if you don't have the right document preservation policies in place, which can obviously be a huge determining factor in the arbitration, and most likely will go against you if you're not able to provide supporting documents for your own case. The second is inconsistent witness testimony. In companies, a lot of people who are at higher posts, they end up moving away from companies. Not everyone sticks around with the company. They move to other organizations. They move to potentially subsidiary or foreign entities of that company. And when they do so, they lose interest in the original company. While they would have been the real repository of all the information and potentially the right witnesses, they may not be that much volunteering to give a witness testimony for events which happened 7 years back and they have already moved on in their life. And that can lead to a lot of inconsistency because then lawyers work with clients to try and come up with the best witness evidence. And if that best witness is not willing to volunteer the right information, then you have to conjure up with respect to your existing resources. And there can be inconsistencies because that person possibly wasn't in the know-how of each and everything that was happening back in the day. So there can be a lot of inconsistencies when it comes to witness testimony, and you have to be very careful before finalizing a witness statement with the client and then submitting it before the tribunal to ensure that it is in sync with the rest of your case. The third is sometimes certain lawyers end up over lawyering procedural points. And when I look at these things, I always think that you don't win an M&A arbitration or any arbitration by focusing on footnotes to the procedural order. Yes, they are relevant, but they are not the most determinative that you will over lawyer on small aspects on certain kinds of how to make the pleading, or if you want to keep on making each and every jurisdictional objection, knowing very well that the fate would be that it will be dismissed against you, but you just want to delay things. I don't think you are doing good justice to your clients. The fourth is, I think as lawyers, we always struggle with numbers at times. And to grasp the accounting standards, sometimes there is not enough adequate help which is available. As lawyers, we struggle. The clients sometimes don't want to get the right experts who can help you. Uh, I mean, even at the time of drafting, the accounting standards have not been clearly defined. Sometimes there can be confusion as to what the parties were thinking about when it came to putting in that language of accounting standards, let's say in a price adjustment scenario. As a result of which, that can lead to a lot of disputes, and we have to be very careful on the language that is used. And the last and the final point that I want to make is with respect to closing accounts disputes without any standards. Generally parties, if they're relying on closing account mechanisms without pre-agreed accounting standards or templates, that can often or more often than not lead to ambiguity and protracted battles with respect to experts or arbitration. And As a result of which, you have to again think through all these things carefully to ensure all of this doesn't happen. And when it does happen, then ensure you have the right experts, etc., to guide you and navigate you through all these issues. So key takeaway is M&A arbitrations are won or lost on clarity of evidence and financial precision and witness testimony and not procedural sparring.
You Karthikeya. Actually, you may have referenced some of this already, but possibly just looking at the other side of this coin, which is that, what steps do you think parties can take at the contract drafting stage to mitigate some of these risks and pitfalls that you've just outlined?
So, Sneha, the first point is that you need to have clear and consistent definitions in your transaction documents. I think you have to really, really spend time with your lawyers and think about things very clearly as to what you're trying to say, whether the language adequately captures what you're trying to say, and it tries to eliminate the risk if things go south from your that time understanding of things. As a result of which, make sure there is clarity and consistency in definitions and defined terms and whatever risk that you want to allocate. The second is start thinking about the dispute resolution mechanism and start working with dispute resolution lawyers early on to try and factor all sorts of risk if things start going south, and figuring out what is the right dispute resolution mechanism to take care of that risk when it goes south. Then third is price adjustment. We've spoken about price adjustment so often in this webinar because it is one of the most common disputes. And again, think through it, work with people who are experts, work with accountants, work with your merchant bankers, and understand whether the price adjustment mechanism works. Understand that there are no breaks, understand that all the closing formalities, everything that you wanted to say, which works as part of the mechanism, is actually functional and there is no ambiguity. Very, very important. And then fourth, which is not very common under Indian law governed contracts, is think about expert determination. Raj alluded to it when he was talking about different forms of dispute resolution, but expert determination for complex financial issues like accounting standards and how to come up with price adjustment can become much more effective than trying to go for arbitration, because those financial experts actually understand that better than people who are trained as lawyers and are now sitting as arbitrators. As a result of which, think about that, whether you can use it, and if you can use it, then whether you can define it in a certain time without any hearing. It can really reduce costs and ensure that the deal closes soon, and then after the closure, if there is any ambiguity on price adjustment, then that gets paid and you move on with life.
Thank you, Karthikeya. Actually, that is true, isn't it? Like the cost of conducting an entire arbitration is so significant that it is one of the major factors that parties tend to consider before triggering a dispute resolution mechanism under a contract. So, Raj, this one's for you. In your view, what should parties budget for as direct costs when they're looking at an M&A arbitration of this size and scale?
When we're looking at large-scale M&A disputes, and it also depends upon where they are seated, right? Because it's in India or it's seated outside of India. So if it's seated outside of India, you may also need to factor in the local law firms, the local lawyers' cost as well. But by and large, what you factor in is the cost of the law firm that you hire, the cost of arbitrators that you hire, the cost of the institution that you will hire, that you would have selected. These are your major key direct costs that you would have. Other than that, if you have a co-counsel because it's in a different jurisdiction, then the cost of the co-counsel in the different jurisdiction is an additional cost that you have to factor in. So these are some of the direct costs that you will have to factor in before you go into an arbitration.
Thank you, Raj. Actually, just again looking at the other side of the same issue, really, what are then the hidden costs that parties should be aware of before they trigger dispute resolution of this nature?
Yeah, I think some of the hidden costs Karthikeya did very nicely cover in his earlier session as well. Is that, see, it's very important that while you're going into arbitration, what are the factors that you have to keep in mind? when you go into a large arbitration, there is always the time that the management spends, right? And the management is caught up doing certain disputes and helping during the arbitration phase and spending its time in making decisions and all of that in the arbitration. So you're distracting the management time. So that's a very critical hidden cost that the company needs to keep in mind. It's time and the resources that the management has to deploy. The second is document production and e-discovery, the time that it will take to do the document production, the manner in which the documents have been kept, they have to be produced. All of that will take a lot of time. The other part that we generally see is the opportunity cost. While the management spends its time in looking at the arbitration, during this period, are they losing out on some very important transactions? And is there an opportunity loss there? Is the third is the time taken in going to courts. Now, those are not sometimes that you can directly relate to, because there could be applications that can go to court on a regular basis, and that can delay your entire arbitration, and the cost could increase multifold. Again, the enforcement mechanism at the end of the award would also be very, very critical to keep in mind. And of course, at the end of all of this, the reputation of the organization as well uh, comes into play, which has its own impact. That if it's found that a particular organization has gone into a long-term dispute with a particular party, does it have any reputational impact? These are all hidden costs that one needs to keep in mind. Yeah.
Thank you, Raj. It's actually true, isn't it? It doesn't show or it doesn't trigger up front, but is the practical impact of triggering a dispute. Which brings me to the next question for you, actually, Karthike, which is what steps do you think that parties can take to manage costs effectively in such arbitrations?
Sneha, I'll
So
highlight some of the important things that I have actually used very recently in a couple of my cases. And that's also because of the procedural innovation that a lot of the institutional rules are undergoing. Uh, but before I talk about institutional rules and what they have come up with innovations, let me say as a general principle, there are things that we as lawyers can really do for certain parties, and hopefully the parties will not insist on the other contrary position. The first is that we should always try and look for targeted discovery. We cannot have a fishing expedition in which we are asking for 100 requests of documents. We should look for very, very specific categories of documents, which can help ensure that the cost in the document production phase is fairly controlled. The second is that us as lawyers, we should be very mindful of who we are putting as expert witnesses and factual witnesses. We should be asking, do we need three experts to say similar points? Do we need five factual witnesses to again make the same point? Or can it be done with one each? So if we limit the number of experts and factual witnesses, that helps in controlling the cost to a large extent. If you just keep on adding experts and witnesses, the cost can really balloon because the amount of pleadings and the amount of consistency checks that you have to do, and then you have to do cross-examination at hearing. So the hearing days increase. All of that really, really leads to exponential costs. The third is in relation to exploring mediation while there are certain gates in the dispute resolution process. Now, even if you haven't agreed to for a formal mediation, us as lawyers need to be very mindful as to when a potential settlement opportunity arises in the arbitration process. If you are at a stronger footing, you may want to reach out to the other side and say that, listen, if you don't agree, then we are going to go through all of this and you can see what your fate is. As a result of which, would you like to enter into without prejudice discussions? And of course, you can do that without actually staying the arbitration. The arbitration can go on in parallel and you can enter into mediation in parallel. So that's something that lawyers should be more and more proactive about and talk to their clients as the arbitration is going, and not something to look at it only when the arbitration process is over or when it is about to commence. I think this is something which needs to be revisited throughout the entire process of arbitration. And now I want to talk about the institutional mechanisms. SEAC, in its recent revision to rules, has come up with a lot of innovative things like streamlined procedure. So if the cases are very small, under $1 million, you can go for streamlined procedure. The proceedings have to be concluded within 3 months. There are strikeout provisions. So if the claim or the defense doesn't make any sense, then you can basically go and ask for a strikeout, which can basically eliminate that claim or counterclaim. So you have to use the institutional mechanisms properly. And while many users may think that institutional arbitration can be expensive, but actually, if you really think of it, and if you have all these variety of things available as part of your arbitration suite under the institutional rules, it is much better. It is much, much better than an ad hoc arbitration. It is much more streamlined. It makes things happen very efficiently according to best international practices. And if lawyers are aware of all the things which are available under the institutional rules, then they can really make things happen in a very targeted and cost efficient manner.
Thank you, Karthikeya. Actually, I couldn't agree more, especially with the newer editions. I think it's no longer an issue of adopting boilerplate rules, like you just mentioned. Even the rules have opt-in and opt-out provisions, which actually, if effectively examined in context of the contract, could potentially reduce costs significantly for the parties. While we have a bunch of other things to cover, given we're nearly out of time, there are a few audience questions that have come in. I think that we can take up before we close. The first one for you, Raj, is how should in-house teams prepare for a possible M&A arbitration even before a dispute arises?
I think it's a very, very important question, a very good question. I think in-house teams play really a vital role in proactively preparing for a potential M&A arbitration, right? Every in-house team knows what it's likely to come. So what they really need to do and probably can do is diligently do some document management and record keeping. I think that's very, very important. Maintaining organized files, easily available records, all correspondences, minutes of meetings, emails, transaction related files, ensure all representation or all materials related to the representations and warranties that have been given, all closing conditions have been complied with, all post-closing obligations have been complied with. Ensure that all of this is well documented and very well kept. You have a good kind of you identify a individual in the organization who will be kind of your record keeper, who will have all the information at the right time. Identify in the event if it goes into a dispute, who will be the people who will be willing to give evidence or who will be the best people to give evidence on a particular issue. Identify them, keep them so that there is no problem at the time when it goes into arbitration. The other thing that the in-house teams should also do is an early risk assessment. Uh, when the dispute has probably not yet started, but you see a first light that there is potential dispute brewing, it's very important to do some early risk assessment. Get the teams which are dealing on the transaction or dealing with people in related to that agreement are given certain trainings. Bring in an external law firm if you have to at that point in time, so that the correspondence that go through or anything that you do subsequently is already legally vetted and the right kind of responses are going. It's very, very important. So you engage law firms at the early stage. You also ensure that all your obligations under the contract have been already complied with. You've taken care that you have not missed out on complying with any obligations that were on your side. Create an internal dispute resolution protocol as to if there is an escalation, who will be the people taking calls. If there is higher issues that are involved, how quickly and how soon can we get the access to the management to get the response on certain issues. That makes very easy if the matter is going to dispute or certain things suddenly blow up. So therefore, in summary, I would say the proactive preparation through robust systems, quality drafting, early assessment, team training, empowering in-house teams to respond efficiently, bringing in the external lawyers, help you to kind of prepare the in-house teams much better.
Thank you, Raj. I'm sure all very helpful points for in-house teams to sort of bear in mind. We've discussed like the whole gamut of preparing for and running through an arbitration. Perhaps the one element that remains to be addressed is enforcement. So, Raj, this one's again for you. How easy, in your view, is it to enforce an India-seated arbitration award in any other country in the world?
So enforcement is the unruly horse, right? Everybody gets the award, but enforcement is always the challenge. So while getting an award is much easier, the time frame is easy, predictable. Enforcement is the one which takes time. Now, the key thing for an India-seated award to be enforced outside of India is that where you are going to enforce an award, that country should be signatory to the New York Convention. It's very important. India is a signatory to the New York Convention. New York Convention has around 150, 160 parties who have signed the New York Convention. Now, so when you are taking an award to a country where you want to enforce it, it is important that both countries are signatories to the New York Convention. Once they are signatory to the New York Convention, both parties, the enforcement becomes that much more easier and that much more streamlined as compared to taking an award to a country where there is no reciprocity or that the country is not signatory to the New York Convention. Once the the award goes to the New York Convention, then then what the courts look at is very little. It's whether it is in the violation of public policy of that country, whether due process has been followed, whether any procedural defects. So these are limited issues on which they will check. They will not otherwise reopen the award. But the important thing that you also must keep in mind is when you're taking an award outside of India, taking Indian award outside India, you must ensure what are the requirements of that jurisdiction. If there are any particular requirement of that jurisdiction, whether you need to go to court to get the award ratified, or is there any other process? So that's also an important thing that you have to keep in mind while you take an award outside of India, be it to New York Convention country or a non-New York Convention country. Yeah.
Oh, thank you, Raj. Of course, very significant points for parties to bear in mind because ultimately what you want in your hands is an enforceable award and not just an award. But before I let you go, we're nearly out of time. This one's for you, Karthikeya. Can you share an example of, in your experience, what has been a well-managed or what should be a well-managed M&A arbitration?
Sneha, I recently did a case which was in relation to price adjustment in a pharmaceutical sector. And the price adjustment was tied to certain regulatory related approvals. And if this thing happens by X date, etc., then the price will get moved. Uh, the contract was governed by English law. It was a European party acquiring an Indian entity. And under the contract, what was provided was that the price adjustment will be determined by an expert within a 6-month window with no hearing. The expert will just get written submissions, 2 rounds of written submissions, and the 2 rounds were agreed between the two parties. We were against an international law firm, and it was very, very well lawyered in the sense that we didn't really fight about procedural, small skirmishes. We knew how to try and get a procedure agreed by working with the counterparty. And then we had expert determination after 6 months on that particular issue. And the other side respected that. So it was one of the most well run disputes in relation to M&A that I did. But the irony is that it was not an arbitration and it was the most efficient M&A dispute that I have run. So the point is that everything is to be tailored depending on what kind of an issue you are facing, and the solutions may lie from a slightly different course than what parties are expecting. So not arbitration is not the end for all kinds of disputes when it comes to an M&A transaction.
Thank you, Kartike. Actually, two very important points that you made, isn't it? Which is that, uh, I mean, lawyers don't need to get adversarial in a dispute necessarily for procedural aspects. And second, of course, is parties willing to actually take the award on its face and allow for enforcement rather than keep challenging it. I think 2 points that we see challenges on, at least as far as India is concerned. So just again to flip the coin the other way, Raj, before we let you go. Conversely, in your experience, what can lead to an M&A arbitration being badly managed?
It's a very interesting questions here. We've seen matters in the past. Point in case, you can look at the Daiichi matter, or you can look at the Tata Docomo matter, or you can look at the SR matter, where there have been things which have gone wrong and which has resulted in long drawn arbitrations. Uh, some of the things that we've seen regularly that can go really bad are the insufficient due diligence and disclosure failures that happen at the time of entering into the contract, the complex cross-border enforcement mechanisms that are there. There are generally that we've seen is there are reputational and operational and financial damages that happen because of going into such long-winded arbitrations. So it's very important that you do a robust due diligence and have a clear and enforceable representations and warranties in your transaction documents. You have good cross-border enforcement mechanisms in your transaction documents. Uh, Now, you also need to keep in mind how are you taking care of the regulatory issues, because there's always going to be regulatory challenges that will come into play. We've seen that in the case of Tata Docomo, where there were regulatory challenges. So therefore, it's important that how are you keeping that in play. Otherwise, if you have not thought of it at the time of entering into the the agreement, they can come back to bite you at the time of arbitration and enforcement. Uh, Again, how many parties are likely to be involved? So complexity of multi-party arbitrations you have to keep in mind. You have to also keep in mind protracted nature of disputes. Parties are very easily nowadays able to drag on the disputes if you are not vigilant and not taking proactive steps to ensure that you kept enough provisions in your contract and at the time of arbitration that you are able to streamline the arbitration and take it to its logical conclusion. Thank you, Sneha.
Thank you, Raj. Thank you, Karthikeya. Thank you, Raj, so much for your time and expertise. We are out of time at this point, but I'm sure our listeners today have benefited immensely. For my part, at least, I think the key takeaways have been significant in that, preparation is the key. Make sure you take enough time to get your diligence done. Make sure you're factoring your diligence risks clearly and unambiguously in your contracts. Make sure you're thinking about your enforcement mechanisms well in advance. Please do involve your disputes colleagues, whether internal or external, well in advance, so they're able to advise you, they're able to oversee what sort of enforcement mechanisms you're going to need. Consider multi-tiered dispute resolution mechanisms if the structure of the contract warrants it, like Karthikeya mentioned and Raj mentioned as well. Mediation, negotiation, conciliation, expert determination can all be excellent even when drafting your clauses. Please beware that it's no longer a situation where institutional rules need to be adopted boilerplate. Especially the more recent versions of the institutional rules allow for various opt-in, opt-out provisions. Please consider them well in advance. Cost management, of course, a big concern for in-house teams. Again, our experts today have shared their valuable inputs on, how this can be better managed. We hope you'll have found all of this informative and useful. Before we leave, could I please ask each of you to respond to a poll that we'd like to put up on the screen for today's webinar? We take your feedback very seriously and would really value it. Thank you. Thank you so much, everyone, for taking the time out to do this. Thank you, Raj and Karthikeya, for taking the time out to be here. We will, of course, be sharing the notes of the webinar as well as the presentation details with you separately offline. Thanks again for being with us. Please do write to us if you would like to see more of these webinars, whether on this topic or any others. Thanks again.
Thank you. Thank you, Sneh.
Thank you all.